Ladies and gentlemen, dear colleagues and friends of the Käte Hamburger Center, Law is Culture. A very, very warm welcome to all of you to our forum night today. A warm welcome, especially on this very cold evening, and I'm really happy that so many of you made it here despite the cold, and I am sure you will be plentiful rewarded by tonight's lecture. Our speaker is Professor Peter Schneck from the University of Osnabrück, who will give a talk on the hermeneutics of property, Francis Lieber on copyright, labor, and textual interpretation. The concept of property constitutes a fascinating and a very challenging topic for our transdisciplinary debates. Social practices and cultural perceptions of property are omnipresent. However, they vary largely from one society to another as to its forms and legal notions throughout history, depending on the prevailing economic and political system. Legal regimes provide very different answers to the question how property rights are defined. Thus, they diverge, in particular, as to the rights associated with it, such as the right to exclude others from access, or as to the possibilities to transfer property. Also, what are the obligations of the holder of the property right towards the general public? Are the public or the state entitled to make use of the property under certain conditions? With literary or intellectual property, its social and cultural embeddedness becomes particularly evident. Here, from a historical perspective, a deep transatlantic divide may be diagnosed concerning the legal construction of the author's intellectual property of his or her work. Whereas the continental concept focuses on the right of the author or droit d'auteur, the common law copyright emphasizes the economic perspective, with the author as someone to work for hire. To this day, it remains a fundamental challenge how to balance the diverging interests. The author's individual rights on the one hand, and the economic interests of publishers, as well as the public's interest in the wider distribution of creative work on the other hand. With today's global dissemination of literary and artistic work by way of online publishing and social networks, this becomes ever more pressing, as does the need for a uniform approach, since divergences might constitute obstacles to the dissemination of literary work. It is therefore worthwhile to look back at what has been called the Transatlantic Copyright War, and in particular the cultural, political, and economic factors that impacted on the development of the concept of literary as well as other property. Here, Francis Lieber comes into play. Born as a German, he became a leading intellectual figure in the US in the 19th century with his influential Letter on International Copyright, as well as other major works, bringing together the European and the US perspective. Before I will give the floor to our speaker, it is my pleasure to introduce Professor Peter Schneck, expert in the field of US American culture and literature, its history, and in particular the rhetoric and representation of property and ownership in US culture. Peter Schneck studied North American and media studies at the John F. Kennedy Institute of the Free University Berlin, where he received his doctorate for a thesis on cultural perception and imagination in American realist painting and literature in 1996. And after the completion of his habilitation on the topic, Rhetoric and Evidence, Legal Conflict and Literary Representation in American Culture, he first taught at the University of Munich and is now holder of a chair at the University of Osnabrück. Various prestigious scholarships, fellowships, and teaching assignments took Peter Schneck abroad, among others, to the University of California, Irvine, Venice International University, University of Nottingham, University of Turin, Smithsonian Institute, and I think I could go on for a while. His research interests are the history of the US-American culture and literature, with a special focus on the 19th century to the present, law and literature, as well as the general question on the relationship between cognition, poetics, and aesthetics in literature. Peter has published widely in these areas, edited numerous books, and written many articles. Since October 2018, he is pursuing his research project here at our Center, Law as Culture, and we are very much looking forward to listening to you now. Thank you.
Thank you, Nina, for this very generous introduction. I just learned today that the famous comedian Heinz Erhardt always wore glasses, but those were not real glasses. He needed glasses, but he used glasses with simple glass, so he could not see the audience. The audience was blurred, so I won't go that far, but I have to take this off in order to see my writing. I wanted to thank Werner and Clemens and Nina, the colleague. I feel very honored and indeed privileged as a fellow to be at this place at this moment. This is a tremendous opportunity I have been offered, and I have enjoyed the scholarly congeniality and conviviality qualities that are so often missing from our usual academic exchanges. Thanks for inviting me and giving me the most precious gift you can give to a scholar: time to think, discuss, experiment, explore, and develop new ideas. The Colleg is a truly wonderful place, and if it didn't exist already, one would have to invent it. Thank you, Werner, for inventing it. And thank you for your generous hospitality. What I will talk about today is very much work in progress, and I would very much like to invite your questions and comments afterwards, but let me give you a short roadmap of the steps I will take here. First, I want to briefly situate my research and my interest in what I would call the cultural history of literary property by asking a few guiding questions. Since most of you, I'm afraid, have probably never heard of my main historical actor, Francis Lieber, I will then shortly introduce the man. The main part will be a more detailed discussion of Lieber's treatise on copyright within the context of 19th century debates on international copyright, but specifically in the context of Lieber's own works on political ethics and legal interpretation. And I will end with a brief remark and maybe some questions about the fate of political discourse or civil discourse in the age of corporate propertization. So the most simple way to summarize my particular interest in the cultural history of literary property would be to ask, how can literature, or even more, how can ideas be owned? If intellectual property defines the ways in which ideas can be owned, and I will briefly caveat, right, I know that property law does not talk about the ownership of ideas or property in ideas, but I will come back to this. So my question, however, is how the idea that ideas can be owned developed. If intellectual property defines the way in which ideas can be owned in a legal sense, my question reaches beyond that definition, or better, the definitions or regulations of property law, to look at the cultural, that is the normative, broader normative, but also pragmatic understanding of owning ideas. What does it mean to have own ideas, to own ideas? How do we use, share, exchange, or even capitalize, or rob, or appropriate ideas? Given that notions about ownership in this wider sense are not necessarily fully congruent with the legal notions and definitions, they present claims, most basically claims for rightful ownership. From this perspective, literary property seems to present something of a paradox, since it may be claimed by individuals, that is authors or publishers, but also by or in the name of collectives, reading audiences, nations, groups. But even though one could enumerate a number of aspects in which intellectual or literary property differs from other forms of property, my question also tries to keep in mind that notions of property and ownership interact. Different notions of ownership and property interact. Sometimes they are intertwined or even interdependent. New forms of property or claims for property, which includes the propertization of already existing cultural products or practices, are not intuited ex nihilo, as it were, but mostly formed by way of analogy to existing forms of property. Lastly, literature might be itself regarded as a form of appropriation, a claim for ownership, specific or even privileged, for instance, by claiming a specific subject matter or a specific style as one's own. If you find this somewhat eccentric, think about the practice of 19th century photographers who would fence off and cover the most attractive views of Niagara Falls in order to claim the view for their images. A practice which finds a current echo in the so-called freedom of panorama laws, or more precisely in the laws that do not grant these freedoms. The second aspect, history. Historically, literary property, and I use this term quite deliberately, it's a term that is familiar in the English-speaking world, but not in the German-speaking world. I use it to sign or to signal that I mean it in the most broadest sense. Literature as property, but literature also as a form of property. Marx literary property, the modern form of literary property, marks a decisive shift or transformation in the understanding of property in general, or more precisely of the object that could become or be property. As Martin Kamen has observed some while ago, the struggle for copyright legislation and the definition of authors' laws or rights since the 17th century onward has to be understood within the context of larger shifts and changes. So literature or literary property is a new form of property that becomes a signature form of property. Kamen writes, through the 17th and 18th centuries, property was undergoing a profound change. Rather than the natural solidity of land, property was increasingly taking the form of signifiers of abstract value, paper bearing promises of future expectations, whose reality at the moment was only imaginary and whose value was defined not by substance or use, but by a deferred closure or by the price for which it could be sold, or people could be persuaded to believe it might later fetch. For obvious reasons, the literary was to prove paradigmatic of the new forms of property, and the book trade was to become both materially and symbolically a significant context for the commerce in such properties. The literary scholar Karen Ear has likewise argued that literary property anticipates, in exemplary fashion, new forms of speculative property, the forms and legal concepts of investment capitalism, which makes and drives accumulation and colonial expansion. Legal scholars have in kind supported the argument that literary and intellectual property develops into a leading concept of property from the 18th century onwards. However one takes these observations, they point to the fact that literary and intellectual property are elements, and more important elements, within a political economy. Thus, a cultural history of literary property would have to take into account its particular status and function within changing contexts of political economies. The market of publications, obviously, for instance, but also the market of criticism, of education, as well as political and legal institutions like censorship, libel laws, information and communication laws. This brings me to the central discussion of my talk, the debate about international copyright regulation in the US during the 19th century and the peculiar transformation of Franz Lieber into Francis Lieber. Here is Franz Lieber, in 1825. And here's Francis Lieber. It's the same person. So this happens to you when you age. This is okay. So it's a curious figure who was highly influential and well known, and now is almost virtually forgotten. A transitional figure between an old order and a new one, who never formally studied law, has no law degree, but a doctor in mathematics, which he took in 2 years in Jena. It wasn't so long ago that he was important enough for Hugo Preuss to write a short biographical sketch, which I would like to dedicate to Werner Gebhardt's bibliothek, library. So if anyone wants to see what praise Hugo Preuss heaps on Francis Lieber, it's interesting to see. So who was he? Now, if any attempt to talk about Francis Lieber leads to a string of anecdotes that are very fantastic, I will only point out very few. So he fights against Napoleon. He is a radical patriot. Because of this closeness to the Jan movement and the Burschenschaften, he was incarcerated twice and persecuted by the Prussian state. He joins the Greek Revolution, and there's this wonderful story how he forged passports to go through several countries in order to join the Greek Revolution, but joined the wrong party, who robbed him blind, and he finally ended on the doorsteps of Berthold Niebuhr in Rome, who was then the ambassador to the Vatican See, who took him under his wings. And it's exactly the tutelage of by Niebuhr that was to prove most influential, because he learned the historical method from Niebuhr. So this is his most influential teacher. He was only there for a year, a little bit more than a year. Later wrote a book about it. He always wrote a book about the things that he did. So he went to Rome, back to Germany, was jailed again, released on account of Niebuhr's intervention, then goes to England, meets his wife while tutoring a banker, is invited to America to organize a swimming club, the first public swimming pool in Boston, and I'm sorry, I have to go back. Gains then national influence and recognition by turning the Brockhaus into the Encyclopedia Americana. It is the only encyclopedia of its kind for 30 years in America, and Abraham Lincoln had a selection or collection of the encyclopedia. So they say what we know is that the Encyclopedia Americana was an important source for Tocqueville, and Lieber translated Tocqueville into English, and he also had contact to important figures, politicians, lawyers like Kent and Story, but also Karl Arnold Mittermeier of Heidelberg. It's also, but more important for our purposes, to note that the edition of the Encyclopedia Americana put Lieber in a unique position in terms of the market of publication, because he was an author, an editor, a publisher, an academic, a scholar, interested in law, economy, and politics. He was a public intellectual, very much recognized. He called himself a publicist, which is one of the many words that he invented. He was also very much interested in forging new language. In the 1830s, he ended up at South Carolina College, which is now the University of South Carolina, but then was a sleepy institution in a sleepy town, and he wasn't very happy to be there, but of course he had to make a living, and he felt very much out of place there. But he used the time to write his most important works on political ethics, legal interpretation, property and labor, and finally on civil liberty and self-government. His central motto was no rights without duties, no duties without rights. He later became the first professor for political science at Columbia University, and this was his suggestion. Yeah, there was a time where you could choose your nomination. You go in there and say, "Yeah, well, I will work for you, but only if you call me a professor of political science." So this was the first time they had it, and this is now Columbia University, of course. And another important thing to mention is he is the drafter of the Lieber Code, instruction number 100, which was mandated by Lincoln in 1863. And it's an instruction for the government of armies in the field, which later became the basis for the Hague Conventions. And this is why they have a Francis Lieber Prize in Switzerland, because Planchy based his work on Lieber's work. So I just wanted to give you the brief list of some of the works that I will refer to. I cannot possibly talk about all of them, but I will turn to one or the other. So let's turn to the central debate about literary property in 19th century America. And as I said, Lieber was in a unique position to tackle this problematic question, but why was it problematic? Why was it especially problematic for the US? Basically, the legal understanding of copyright in America was informed by two independent approaches. On the one hand, the copyright clause in the Constitution protects for a limited time the exclusive rights of authors and inventors. That is, it treats intellectual property in the same way as it does patents, more or less. The other source for copyright legislation was, of course, English precedent and statutes, which were referred to repeatedly and discussed in the legal literature of the day. American authors thus roughly were granted rights similar to English authors in their country. That was the frame of reference, basically, the most important frame of reference. So there was no problem with copyright, basically. The problem was that what was not protected was the work of foreign authors, which included English authors. This created an increasingly problematic situation the more the market for publications expanded in the US on the one hand, and the more American authors could capture readerships beyond their American audiences. So they form a single market, basically, the two, but of course they differ according to their protection that they give their authors. As long as English authors were pirated, massively pirated in the US, American authors' works were not protected in the English market. That is, American authors and English authors and their publishers. The English publishers suffered, while the American publishers could feed the increasing readership with cheap editions and expand their home markets. So this is the basic problem, very rough and ready sketch of what is at stake. This led to an increasing discussion, increasing widespread discussion about the nature of literary property and the nature of ownership by authorship, in which literary authors played a significant role. So when you look at English and American literature of the time, 19th century, you will find that almost all of them are involved some way or other in this debate. Scott, Cooper, Dickens even went to America to fight for copyright protection, Beecher Stowe, Henry James. It goes on until at the end of the 19th century, with the Chafe Act, America installed some sort of mutual protection, but it took a long time till the US signed the Berne Convention, which is the basic framework for the protection. Now this created in the 19th century a collision between the interest of publishers and the interest of authors within the framework of international copyright regulations and conventions, which also meant that the focus of the discussion was on the universal rights of authors, which could be argued as transcending the legal framework of national copyright institutions. Was there a natural, even a perpetual moral right of authors? This is why the debate about international copyright in the US was much more fundamental and resonated strongly with other contemporary debates about property rights. For instance, women's property rights, but also, and much more complicated, with the discussion or the debate, the struggle about slavery, slave labor, and industrial labor. All these debates get intertwined. So this is a resonating network of debates about property and rights. This has to be kept in mind when we take a closer look at Lieber's contribution to the debate. And this is where I will turn from my little notes to a text that goes a little bit more into detail. Okay. In his 2014 History of Copyright in Europe and the US, the historian Peter Baldwin contends that current struggles for the function, the extent, and the limit of copyright protection are driven by a basic dispute between two different approaches. You already mentioned that. That's a great coincidence. To intellectual property. A dispute, moreover, that, as Baldwin writes, quote, has been with us for almost 3 centuries and continues into the digital age, unquote. The Copyright Wars, that's the title of the book, which Baldwin traces from the 18th century onwards to our times, are, quote, 3 centuries of transatlantic battle. That's the subtitle of the book. Characterized above all by the persistent antagonism between what Baldwin calls the Anglo-American system of copyright and the continental European system of authors' rights. The former is built around the core doctrine of work for hire, meaning that, quote, when Anglophone authors sell rights to publishers and other disseminators, they lose almost all control, while the new owners are largely free to do as they please, unquote. This fundamental orientation of Anglo-American copyright, quote, transforms the employer, the author, into not only the owner, the employer, into not only the owner, but also the legal author of his employee's work, unquote. In contrast, the, quote, continental ideology of authors' rights, unquote, acknowledges the moral rights of authors, quote, even after economic rights have been alienated, thus ensuring them the aesthetic control over the works even after sale. These are all quotes from Baldwin. The most decisive contrast between the two doctrines or ideologies, however, lies less in the different status assigned to the author and the extension of her particular rights, but rather in the distinct way in which each of the systems acknowledges the role of the public, the readers, the audience, the consumers, however one wants to call them. As Baldwin writes, and I quote, two different approaches, Anglo-American copyright and continental European authors' rights, thus have voiced divergent views of intellectual property. Copyright was intended to give authors sufficient encouragement to remain fruitful, thus enriching the public domain and serving useful social functions, to enlighten, entertain, and educate. In authors' rights systems, in contrast, the author was the focus, not the public domain, nor the audience. Thanks to this investment of labor and creativity, the author owned his works like other forms of property. To guarantee his just deserts when he sold them in the marketplace was the point of the continental approach, unquote. On the face of it, this might suggest that Baldwin is simply rehearsing a contrast that has been a staple of comparative studies of copyright in the US and elsewhere for quite some time. But there is something more at stake in the transatlantic battle about copyright that Baldwin is trying to account for, as his numerous polemical asides and rather gleeful anecdotes of the more excessive legal consequences of the continental ideology make clear. Notions about the timeless moral rights of authors are not only logically misleading, but also legally confusing and politically and culturally detrimental. That's from his point of view. What is more, in the grand narrative which the copyright wars attempt to cover, European ideology has finally trumped Anglo-American common sense, and what has been polemically criticized as the Americanization of intellectual property rights, that's Eva Hemmungsvirtin, a Norwegian scholar, is actually the gradually and erosive Europeanization of the Anglo-American copyright system meant to serve the common good. Kant, Hegel, and Zola are the true originators of WIPO, TRIPS, and digital rights management. Not to mention the Sonny Bono, Jack Valenti Disney Copyright Extension Act, signed by Bill Clinton in 1998, which finally introduced European standards of copyright terms, plus 70 years after the death of the author, into US law. While the central tenets of his diagnosis can hardly be questioned, Baldwin's attempt to identify a cultural character of copyright discourses in legislation may only serve a more general rhetorical aim. In the following discussion, I want to revise, or maybe better, critically complement Baldwin's approach a bit in pointing out both the complexity and the intensity of cultural exchange and intercultural negotiation which went into the debate about literary property and international copyright in 19th century America. My main example will be the work of Francis Lieber, this 19th century Prussian emigre who came to the US to escape political persecution and turned himself into a successful and highly respected voice in US-American political, legal philosophy and theory. As we have seen, Lieber was and still is a rather fascinating figure, and the most fascinating aspect of his legacy is the fact that his high status among his contemporaries stands in stark contrast to his rather inconspicuous, if not completely obscured, presence in current debates about central legal political issues in the US. Yet, as Mike Robert Horenstein observed some time ago about Lieber's obscured presence, it makes the question of, quote, how the force of Lieber's ideas carried them through several ages of American law into the present in areas as diverse as the interpretation of common law precedent, contract, statutory, and constitutional law. All the more interesting, this question, but also a bit more challenging. This appears to me especially true in regard to Lieber's Letter on International Copyright, published in 1840, which has received only little attention in the past and is mostly seen as an obviously self-serving intervention into the intensive debate about authors' rights and their national and international protection in 19th century American culture and politics and law. Moreover, within the impressive flurry of pamphlets that characterized this debate as an attempt to rouse public opinion, Lieber's remarks on literary property, as he consistently terms it, may on first sight appear as a minor text, especially in comparison to the other seminal writings from the same period, which had made Lieber such an influential voice in 19th century America. Among them, his Legal and Political Hermeneutics, the Manual of Political Ethics, and his Civil Liberty and Self-Government. Yet in order to understand his particular concerns for the protection of literary property and authors' rights, Lieber's Letter on International Copyright has to be read precisely in connection to his other works on legal hermeneutics and political ethics. Yet another important point of reference that must be mentioned are Lieber's Essays on Property and Labor, which is actually a collection of his lectures, which he gave in South Carolina College, published only 1 year after the Letter in Copyright, which is widely seen as one of the early and original contributions to law and economics. Taken together, these texts form a network of references and cross-references within the larger system of Lieber's thought on civil society, individual rights, and duties. It would be, of course, futile to attempt a more thorough discussion of the manifold aspects and the complexity of Lieber's system. When you read about Lieber, there is the continuous assessment that Lieber has no system. Of course, he doesn't have a system in the sense that any German philosopher would expect a system at that time, but there is a system. There is logic in the madness, and we have to look for it. And thus, I will concentrate, because of lack of time, we'll concentrate on the copyright essays a little bit and its most pertinent connections to Lieber's thoughts on property in general, and how these may be understood in relation to Lieber's legal and political hermeneutics. I have to check what comes next. Clear blanks. Okay, good. Let me first try to walk you through the main strand of Lieber's argument in this treatise about literary property and the foundation of authors' rights in their creations. I will do this by stringing together a line of short passages quoted from his treatise from the very beginning. Even though this will condense his wide-ranging discussion of numerous older and contemporary sources, it will carve out, I hope, the particular way in which Lieber integrates his discussion of intellectual property into a more general discourse on property, a broader discourse of property in, basically, a foundational way. Okay, here we go. It has ever been most amply acknowledged that whatever a man rightfully or lawfully produces by his own hands and with his own sweat is his and his only. This is a common understanding of the sweat of brow doctrine, it's called. There's Locke in the background, there's Lieber, a labor theory of property rights. But as I said, Lieber builds his argument. Yet, and might be a bit hard to understand, yet no man can create anything. It is a well-acknowledged truth that nowhere an increase of matter takes place. Production does not mean creation. That is a very important moment here. But the greater man's own personal activity, skill, exertion, or sacrifice have been, the more clearly established is also his title of property in his product. At face value, this is a bit difficult to understand because we have a more flexible approach to production, creative production it is. But what is meant is that production may include transformation. You may indeed turn out or produce something new, but you have not increased, you have not created something. This is a difference. And this is the difference that is important for Lieber. Production may include transformation, but it does not include ex nihilo creation. So the Lockean dictum, mixing work with matter, is still valid as the basis foundation. However, there is an increase, obviously, in the justification of legal title for property. The Schutzwürdigkeit goes up, basically. The more intellectual work is being invested. And we see this, okay. And it goes again. But the more a producer unites with his manual labor, intellectual exertion, the more readily does the universal voice of mankind acknowledge his individual title of property in the product. It is important to note the terms that Lieber uses here. The union of manual labor with intellectual investment turns the right into something that is universally acknowledged. An individual title that transcends any national or regional forms of legal regulation. It is a kind of human right, a basic right. Indeed, the more, it goes on, indeed, the more men's judgment and intellect are active in conferring value, the more he approaches to the creating of a new thing. So this is the moment where the process leaves the initial analogy, mixing work and matter, and turns into a form of pure property. So what is being created by intellectual work is a form of property. No. On first glimpse, there is only little which would strike most contemporary readers as unique or unconventional. And I'm not making the claim that this is completely unconventional, just carving out the way in which Lieber builds a case for property rights in intellectual production or creation. In Lieber's remarks on international copyright, indeed, if judged only by the central arguments in favor of authors' rights, one could easily come to the conclusion that Lieber's argument is deeply entrenched in the continental ideology, which Baldwin sketched out in strong terms. So he's a kind of subversive force. This impression may be further encouraged by the fact that Lieber makes recurrent references to existing continental legislation of the time, and especially where those sources support his central conceptual idea of the natural status of literary property, not to be confused with the more general idea of authors' rights as natural rights. There's a difference here. However, he also cites and tries to refute continental sources and voices which are much closer to the Anglo-American work-for-hire concept of literary property, and which conceive of literary property exclusively as a statutory right. From the latter perspective, as Lieber remarks, the whole right of literary property would be a thing absolutely made and invented by government, a monopoly. And this is a very interesting twist of phrase. In this context, Lieber also specifically tackles a French position which rather uncharacteristically also insisted on copyright protection as a statutory right, even though it was a continental ideology. It's the same. Granted by the state, and looked at individual literary property as a mistaken concept to begin with. This particular argument was brought forward by the French jurist Charles Renoir in 1839, and the publication of Renoir's article in the US had some impact on the American debate, and it was also quoted in legal decisions. So there's a mixing of these discourses. And more interestingly yet, the curious way in which Lieber uses the term monopoly here, and on other occasions, to connect it to positions opposed to unlimited authors' rights also points to an inherent strategy to deliberately blur any clear-cut distinction between idealist or natural right conceptions of literary property on the one hand, and more market-conscious, regulative conceptions of temporary copyright protection on the other. For monopoly was a term generally used against proponents of authors' rights as natural rights, whereas in Lieber's letter, the derogatory charge of the term is redirected to imply that it was the statutory perspective which actually introduced or even favored monopolizing literary property, if even only for a short time. So the state helps to build this monopoly. This is exactly what happens when it extends the time again and again and again. It would be a misunderstanding to assume, however, that Lieber was simply trying to denounce the concept of copyright as limited statutory protection of authors' rights in order to support unlimited protection of those rights on the basis of some unalienable moral right. He never talks about moral rights, never. For the rhetoric of monopoly, of the market and economic value of books, and the multiplication of literary works as commodities is contrasted and at the same time complemented by a rhetoric of privilege, censorship, and state power. And this actually shifts the discussion from the economic and the individual towards the political ethics, the political economy. In other words, Lieber clearly aimed to emphasize the political and cultural dimensions of literary property, and thus the status of authorship as a distinct, if not the most distinct, form of individual articulation. The nature of literary property can only be clearly defined by complementing the economic with a political and cultural perspective. In ways that are not always obvious on first sight, Lieber's particular approach to literary property is indebted to a broad range of philosophical arguments and ideas reaching from Kant, Schleiermacher, and Hegel to British moral philosophy and Scottish common sense, combined with, and in obvious ways adapted to, 19th century Anglo-American notions on the political and cultural significance of individual property, what has been called possessive individualism, even though he's a far cry from subscribing to those ideas. The result, then, is a synthesis of various arguments drawn from these different backgrounds, which centers on literary property and authorship as indispensable aspects both for the individual articulation of political and social personhood and the establishment and preservation of a civil society. Literary property and authorship are thus immanently social and political, both in their character and in their effect and function. I want to briefly discuss three central aspects which characterize this particular synthesis that Lieber aimed at. There are two interwoven basic narratives of cultural and social development which organize Lieber's argument, and there's a little bit where Niebuhr comes in with a genetic narrative of development and emergence, history, the historical perspective. One presents a universal or foundational notion of property infused with the pathos of civilization as progress and cultural achievement. The other presents a more historically contextualized notion of literary property and its particular function within the further development of a civil polity. Using these narratives as a general background or frame, Lieber then carves out three central aspects to emphasize the cultural, social, and political, that is, ethical character or function of literary property. Two of these aspects are more explicit, the third one is more or less implicit, albeit the same significance. and I have tried to put this together in these 3 list of keywords or key concepts. So on the one hand, the function of property in general is sustenance. In that sense, property is universal. It talks about a sense for property or a property sense. It's also universal because it then triggers development through creative appropriation, that is, it is cultural, and individuation through articulation and exchange. From the very beginning, property has a social and a political function. Literary property, as an exemplary and foundational form of property in both senses, that is, as a cultural and social articulation in a social network, let's put it that way, what Lieber calls the society. And what he means is not national society, but any form of social compound or collective. The society of societies is the state, in Lieber's understanding. And thirdly, literary production, I call it production even though he calls it creation, or it can be said to be creative. The production of literary property is the most individualized form of participation in the social and political exchange of and the making of meaning, the production of common sense. It's where the individual becomes recognizable as a participating member of the social unity he's part of, member of. Let me briefly comment on each point using a few illustrative quotes from the essay and from some other works mentioned before. To A. Lieber's argument in favor of international copyright rests on a notion of literary property as being merely a specific variant or version of other traditional and well-established forms of individual property. All these forms, including literary property, can thus be understood as different formations or realizations of a universal and original form of appropriation and production. Lieber's ideas of property and the origin of individual property rights are obviously indebted to the most conventional notions of the day. I said this already. For instance, when he writes at the outset that the most undeniable title to individual property has ever been established and must forever be so by personal individual production, that is, changing by personal labor the shape and substance of what exists. Well, that's Locke. The right of calling, that's also Lieber, the right of calling that my own, which I have first appropriated, changed, fashioned, improved, upon which, in short, I have first bestowed value. If it did not belong to someone else before I appropriated it to my particular use, lies beyond absolute proof. To whom should the product belong if not the producer? This familiar understanding of the cultural origins of property in the sense of first occupancy, cultivation, is then taken to support the equally familiar argument that property is not the creation of government, but rather vice versa. As Lieber says or states, property is so direct an effect of man's nature that it precedes government, but not society. So Lieber is not talking about the state of nature. It's very different from the natural right argument of Locke. But he mixes them, you know. This is the interesting thing. An argument which Lieber repeats with even greater force in his essays on property and labor. It may be, he says there, it may be maintained, therefore, with far greater truth, that government is the creature of property. Unquote. What is at stake in these preliminary remarks, on which the further argument for literary property then is built, is the role of government or the state in relation to property, including literary property. As Lieber states, government, being the active exponent of the opinions of the community, consolidates and aids in the further development of those usages respecting the possession and transfer of property and of property itself. Unquote. Thus, not only property itself precedes government, but also all the opinions and usages, which Lieber also calls feelings, in reference to property and its individual and communal functions and effects. And what Lieber is actually describing is that the changing opinions and usages, that is, the practices of ownership, precede their legal regulation, or a new revision of these regulations. He doesn't say it explicitly, but you can read this. The important aspect of this argument is not so much that the sanctity of individual property which the state is meant to protect is rather the control of the opinions and usages of property which are at stake. If property was simply a creature of government or statutory law, opinions and usages which are the product of proprietary relations and practices in a process of constant appropriation and amelioration of what exists would fall under the control of the state. And this is a very important point for Lieber. As Lieber's discussion of censorship throughout the text and his repeated references to the absolutism of monarchical states makes very clear, his perspective on literary property is very much driven by the fear of governmental intervention and control in general, but in particular in respect to the usages and opinions realized and articulated through literary property. Again, it is important to note that while this line of argument was not at all new during this time, Lieber's insistence on the cultural and social precedence of individual property in the context of his letter on international copyright is an obvious attempt to ward off the state's control of individual property because the latter for him is the most significant form of articulation and expression of individuality. As he states in reference to his first volume of the Ethics and Legal Hermeneutics, were supposed to be the first volume of political ethics, so he's referring to his other work, when he insists that control through individual appropriation is at the core of individual property, which in turn proves or realizes man's individuality, quote, property is the reflex of man's all-important individuality in the material world around him. It sounds a little bit like Hegel, but it's not. He didn't like Hegel at all. If this sounds almost like possessive individualism with a Hegelian twist, it again marks the specific synthesis of position and ideas which Lieber was trying to achieve. Moreover, the realization of individuality is nowhere more obvious than in the production, or better, the creation of literary property. The reflex of individuality to the immaterial world of ideas and opinions, as it were. This is clearly expressed in the most emphatic passage of the letter. I quote, both personal and intellectual activity appear clearest in literary production. And we're not talking about the production of literature, obviously. Intellectual work, the productions of intellectual work. And if any product of individual activity has any claim whatever to an individual title of property, it is a literary composition. If there exists any species of property not made by government, but existing by its own spontaneous right, and which requires only to be acknowledged by way of protection on the part of government, it is literary property. If there is any property which does not trench about the rights of others and exists without any sacrifice of theirs, in brief, if there is any property peculiarly innocent and inoffensive in its character, it is literary property. This is a strange phrase to use, but of course it is in comparison to other forms of production that use, for instance, human labor or even slaves. And there is an inherent reference that I will not dive into, but maybe later we can talk about this. Literary property is thus the most exemplary form of property, for it represents the purest manifestation both of individuality as such and of the enjoyment of individual rights protected by the state or by the government. Lieber's emphatic enumeration or even incantation of the particular features of literary property, its characteristic properties as it were, also highlights the way in which this specific form of property aligns the cultural and universal with the social and individual, and eventually the political realization of the individual as a subject of rights. My last point, the shortest and also the most speculative one, concerns the relation between the copyright letter and Lieber's legal and political hermeneutics. And this is my title. What does that have to do with interpretation at all? But of course, we're talking about authorship, and literary production is the intentionally composition of speech. So, Originally, the book, Legal and Political Hermeneutics, was meant as the first volume of the Manual of Political Ethics, so it is safe to say that for Lieber, legal interpretation was both a political and an ethical question. Yet how do these works relate to the question of international copyright? There are indeed several relations, but given the short time that we have left, I will briefly point out what I think is the most significant one before I add some concluding remarks. One of the challenges of that Schleiermacher's hermeneutics, on which Lieber's own system is clearly based, even though there's obvious differences, because Schleiermacher is not talking about legal interpretation. One of the challenges that Schleiermacher's hermeneutics presented was due to its acceptance of the fundamental historicity, both of texts as the expression of the historically bound subjective understanding of authors, and of the interpretations of these texts as the expression of the equally bounded and subjective understanding of readers. The act of interpretation is thus unavoidable as it is unending, especially where texts are either fragmented or their origin is unclear, or both. Historical knowledge thus is indispensable for the act of interpretation, as is the interpreter's awareness of her own historical horizon of understanding. And most obviously, when it comes to the question of the changing meaning of language itself. And Lieber was obsessed with language and changes of languages, and would always try to go back to the sources of a word, and so on. Lieber acknowledges all these central tenets, but since his interest is to offer a systematic approach, or methodic approach, for the interpretation of legal texts, his focus is not merely on textual meaning, but on authorial intention. This focus may help us to understand Lieber's enigmatic introductory remark in his Hermeneutics. And I hope I have this. Okay. This is one of the sentences that have haunted people. No sentence or form of words can have more than one true sense, and this only we have to inquire for. This is the very basis of all interpretation. Interpretation without it has no meaning. This remarkable statement depends on two assumptions, all relating to authorial control and the authenticity of authorship, and the necessary trust of the interpreter in the authenticity of authorial intention. First, the notion that a legal text is deliberately intended to mean something. Its meaning is intentional, not accidental. Second, its intended meaning cannot be self-contradictory or ambivalent. Otherwise, it would not be law. These assumptions are in turn based on another more fundamental presupposition, namely that responsible and reliable authorship is only possible where authors or speakers are in control of their utterances, and their utterances are neither enforced nor censored nor revised after the fact. The protection of intentional and authentic authorship only presents the necessary foundation for an interpretation which can be itself meaningful and which can be presumed in good faith and with common sense. So these are all in the same argument. And I picked some quotes there. The latter, the common sense, has nothing to do with generalized or stereotypical forms of knowledge and opinion common to all, quite the opposite. This common sense is the result of practical experience in this case precisely in legal and political interpretation. It's a professional form of common sense. When common sense is well versed and practiced and judging for the given present case only, we call it tact. That's an interesting reference. Savini talks about tact, Ehring talks about tact. I've yet to find out whether there's a relation or not, but it's an interesting reference towards something in the Anglo-American legal world would be called equity, something like that. Tact is instinctive, practical judgment which has been so well practiced by experience as to operate in ordinary cases so rapidly that we ourselves are unconscious of the operation. Good faith in interpretation means that we conscientiously desire to arrive at truth. It means that we take the words fairly as they were meant. Now, if we take this together, it's obvious that Lieber is not making a case for the one true meaning of the text, it is the one true meaning, the one true sense of the interpretation. It's the relation between the text and each other. From this perspective, the emphasis on and the concern for the protection of authorial control and responsibility expressed in Lieber's letter on international copyright are clearly indebted to the letter's notion and conviction in regard to the interpretation of legal texts. Thus, authorship and interpretation for Lieber were substantially and inevitably politically and culturally constitutive, as complementary practices of free individuals protected by rights and bound by the duties that come with those rights. The freer the country, the more necessary becomes interpretation. For one of the main ingredients of civil liberty, and at the same time one of its greatest blessings, is the protection against individual passion, violence, views, opinions, and caprice, the supremacy of law, of legal interpretation. The authors that Lieber had in mind, and whose rights he wanted to have recognized, were autonomous individuals who produced meaning, new meaning, for social and cultural opinions and usages. They were neither literary geniuses nor merely hired hands. Despite its obvious historical distance to our own situation, Lieber's letter may serve as a reminder that still today the question of ownership in ideas, especially in face of the massive corporate propertization of civil speech and writing, is not just an economic but also a cultural and political question. I will end with one final slide, and is simply transport. As I said, whenever you say this ownership in ideas or property of ideas, lawyers would remind me that the property law exactly make a difference between the idea, which cannot be, and the composition or the expression. But this distinction is precisely what is at stake. So the form of protection and the form of regulation is also a way of owning ideas. And on a more recent source, we find this. In another era, a nation's most valuable assets were its natural resources, coal, say, or amber waves of grain. In the information economy of the 21st century, the most priceless resource is often an idea, along with the right to profit from it. Today, the process for capitalizing, either financially or socially, on innovation and creativity is staggering under the strain of a digital revolution of a speed and scale never seen before, at a time when many of their most valuable assets can be shared and exchanged easily. Businesses and governments scrambling to redefine who owns what. Okay, thank you.